Initially, I'd also like to talk about Mr. Morgan and his comments and the brief concerning the Avenel report. The state in its brief indicates that Mr. Amelia defied the court's order. That, in fact, is wrong. The court's order was for him to attend. The state seems to have forgotten the seminal constitutional principle that people still have, and that's the right to remain silent. Mr. Amelia elected to do that. That is his right. Whether we like Mr. Amelia or we don't like Mr. Amelia, the Constitution still applies to him. That Fifth Amendment right continues to be with Mr. Amelia now, continues to be with him during his appeal, and forever remains with him. So when the state in a sentencing memorandum says that he defied the court's order by failing to talk to the people at Avenel, the state seems to forget that the Constitution still applies to those that have been convicted. State argues aggravating factor number 2. I suggest to the court that it's not there. State says they were targeted due to their young age. The court looks at the authority. The authority talks about young age being something different than the elements of the offense. In these cases, the elements, the age constitutes an element of the particular offense, and we all know that you can't double count. I saw nothing in the aggravating factor 2 which talked about dysfunctional family, which is the only other reference the state made. As to aggravating factor number 3, the risk that they'll commit future offenses, suggests to the court that that's present in virtually all cases. There's always need, or there's always the concern that that may happen. If someone's done it once, they may do it again. State argued number 4 was abuse of trust. State argues that by virtue of, and if I recall correctly, the only one that said anything about Mr. Amelia saying he was a police officer was Ms. Grover, for which there's been no conviction, and that the Claustons didn't. In order to find aggravating factor 4, the court has to take the state's argument that because the uniforms that he had hung on his door, where they hung on his door his entire career, suffices to constitute an abuse of trust, so be it. State says number 9 needs to deter. I can also suggest to the court that that's always present. I suggest to the court the only aggravating factors are 3 and 9. State argues that mitigating factor 7 shouldn't be there because it would, quote, stand it on its head because of the lengthy period of time. But I suggest to the court that this court doesn't know how long it was by virtue of the indictments. And in theory, it could be as short as 2 months. Why? Because the state chose to indict under the OC video from June 8, 2000 to August 17, 2006. We don't know when that video was taken. The state chose to indict OC April of 03 to June 7, 03, and JC from September 5, 02 to September 6, 04. Those events all could have occurred between April 03 and June of 03. We could take the window. And the court has no greater ability to ascertain when those events took place, because as we all know under KAW, the state's obligated to narrow it as much as they can. So we can't say that that's not when they occurred. We have no idea. So to suggest that it was over an extended period of time, over many years, that was never proven. Simply wasn't. We don't know. They never testified as to any specific dates, and in fact, those dates changed. Because as the court will recall, OC was 12 to 13, then she was 14 to 15, then she was over 16. All throughout the course of her statements and her testimony, it was the state that chose to charge it this way. State says in its brief, even after the verdict, they refused to acknowledge their guilt nor show remorse. And I would suggest to the court that approximately 20 to 25 years ago, the prosecutor made that same argument in this very courthouse with regard to Larry Peterson. 18 years after he was convicted and sentenced, Larry Peterson was exonerated and released. Since 1989, 100 people alone in Illinois have been exonerated after having been convicted by a jury of their peers. So to suggest that somehow a verdict obligates or compels them to say they did what they don't believe they did, I believe is inappropriate. The list goes on. court's going to sentence Mr. Miller for the crimes he was convicted. But to suggest that they have to say they're guilty in order to obtain some semblance of leniency from this court, I suggest, isn't an appropriate argument to make, and in fact is offensive. The state suggests to the court that, Your Honor, we could argue for 100 billion years, I exaggerate for the purposes of the argument, but we're not. We're going to be magnanimous. We're only going to argue for 50 and 85% on 3 different kids, and then we're going to argue for the sentence on the other. We're not going to ask for more. But functionally, what does it matter? He's 42 years of age with 226 days of jail credit. I mean, it's borders on absurd to suggest that somehow the state is being magnanimous so that they aren't arguing for as much time as they can. Because functionally, absent a reversal or something, he will be 86 years of age if he survives that long. And we all know that the prison environment is not one that is conducive to lengthy life. He'll be 86 years of age under their magnanimous recommendation. So it really doesn't matter whether the court could give consecutive sentences above and beyond and over again. The state's recommended sentence is essentially a life sentence, no matter how you slice it. And ultimately what this court has to decide is whether, and the court may agree with me. I don't know that. It's the court's decision to make. But the court's decision has to be whether, as a result of the convictions that have been imposed, it warrants a life sentence, because effectively that is what it is. As a practical matter, a 52-year sentence, 45 of which will be subject to the 85% rule, constitutes a life sentence. This court sat through the trial. It saw all the witnesses. The court's going to do what it's going to do. There's nothing I'm going to say to convince the court otherwise. Mr. Amelia stands before the court having been convicted of the offenses, and he understands the ramifications and the consequences. And we're ready for any sentence that the court imposes, and we will move on to the next aspect of the case. Thank you.
Thank you, sir. Ms. Geller,
Thank you, Your Honor.